All right, I want to talk to you about sentencing today. That's the last phase in a criminal proceeding. There's the arrest, the arraignment, pretrial, preliminary hearing, trial, jury deliberations, verdict, and then if there's a guilty verdict, it's the sentence. What is a sentence? Well, it's something that starts with a capital letter and ends with a period, but that's not the type of sentence we're talking about. We're talking about a sentence like a punishment that the judge will hand down once a guilty verdict is returned. And, you have certain rights. It's considered constitutional rights during sentencing. That includes the right to an attorney, the right to be present, the right to introduce evidence. And a lot of times for a defendant, that evidence will be called mitigation. Hey, judge, my client is actually a good person. He's got 3 kids. He's got a wife. They love him. This was a poor judgment on his part. This was an aberration. This isn't really a part of his character. He's somebody who had a drug habit that caused him to do this. Or he's somebody that grew up in very unfortunate circumstances that most people don't have to deal with. And that should be something that reduces his sentence. Now, there's a big difference between misdemeanor and felony sentencing. Misdemeanor sentencing is the max that you could be sentenced on any count is 1 year in prison. Some misdemeanor charges, the max is 6 months, not even a year. And you serve your time in local custody. That's in a county jail, not in a state prison. On the other hand, felonies, they're served, prison time is served in a CDC facility, a state prison, and there's basically 3 options for a judge to decide. Are you going to be sentenced to the low term, the middle term, or a high term? For example, a crime like grand theft, there's a low term of 16 months, a mid-term of 2 years, and a high term of 3 years. The judge has discretion to sentence within that range based on certain factors of the crime itself that come out during the jury trial, or the criminal history or the criminal history of the defendant. Now, in both felonies and misdemeanors, a judge, instead of sentencing to prison time or jail time, can give probation. It's called a grant of probation. And that's certain conditions that a judge will say you have to do to avoid prison. For example, in a felony, hey, you have to do community labor, forced labor. You have to check in with the probation officer every month. You have to attend anger management courses. And if you do all these things and you don't violate your probation, the terms of your probation, like pick up a new case, then you avoid going to prison. If you do violate, then the judge could sentence you to prison up to the maximum term, the high term. Now, after SB 1950, felony probation is typically only 2 years, with certain exceptions, and misdemeanor probation is now only 1 year with specified exceptions after SB 1950. I think sentencing can really be highlighted in the differences between sentencing in a state case and a federal case. In a state case, the sentencing is usually bundled up with the plea agreement. So the defense attorney will negotiate with the prosecutor, and they'll say, okay, we'll plead guilty to this count, and we'll agree to do this much time. And so when the sentence comes around, it's already agreed upon, and the judge can accept it, which they usually do. Occasionally, a judge, seldomly, will reject it and say, no, I don't agree with that sentence. It's, for example, too light. Well, if the judge rejects it, the guilty plea can be withdrawn and the case is reopened and it could be fought and negotiated again. Now, that's a big difference from a federal case where a defendant pleads guilty and the sentencing, not knowing what the judge will do in terms of sentencing. There are federal sentencing guidelines that help guide the judge as to what kind of range he or she should be looking at, but the judge is free to go above that range or below that range. The federal judge has a lot of power during sentencing, and the sentence is not negotiated as part of the plea agreement, as it is with state cases. Now, there's also an important difference in a state case as between a guilty plea and a plea and a verdict, a guilty verdict after a jury trial. In a guilty plea, like I said before, you get to know your sentence beforehand, ahead of time. But when the jury comes back with a guilty verdict, now the judge gets all the power, and he gets to decide what your sentence is going to be. Of course, the law specifies a maximum, but the judge could go all the way up and max you out. And so that's part of the challenge of a jury trial. You're in jeopardy. You're rolling the dice. And if the jury returns a guilty a guilty verdict, then the judge gets to hatch it, and he can use it if he wants to. Now, there's a difference between concurrent sentencing and consecutive sentencing. If you're found guilty on more than one count, concurrent sentencing means it runs at the same time, the two counts. So you don't do any more additional time because you've been found guilty on more than one count. Consecutive time means it's back to back, and you could do basically the two sentences could be added up. So you do more time. It's up to the judge whether you do consecutive or concurrent sentencing. And the defense attorney will usually argue for concurrent, or almost always concurrent sentencing. Now, how can a good lawyer help you in a sentencing hearing? Well, they could humanize you. Like I said, talk to the judge about the enormous disadvantages you've faced, or the fact that this misbehavior was an aberration or was not in your normal character. Defense attorney can help in that way, and so sentencing is very important. Find a good attorney to help you get a good sentence.